Hello and welcome to the third of our series of webinars on ELPL law. I know it's a hot sunny day out there for pretty much everyone, I'd have thought, but hopefully this will be interesting enough to justify being inside. Those who've attended the previous sessions will be familiar with these, but I'll just quickly run through a bit of housekeeping. Everyone's cameras are automatically off. Questions are welcome. The way to ask these is through the Q&A box on your screen. We'll try and leave enough time at the end for questions, but if there are any burning issues as we go along, then feel free to enter those in the box. Everyone's microphones are automatically off. Technical problems, as it says there, check your device settings, try leaving and rejoining, or try disconnecting your monitors. The session is being recorded, so it will be available for future reference. And again, as always, if possible, please could you complete the feedback form so that we can take any lessons from that. I'm pleased to say that today's session will be given by Mark Roberts. You should have his bio available for you on screen, but as this says, he's a very highly regarded specialist personal injury counsel. For some years now, has worked exclusively for defendants and their insurers in all levels of personal injury litigation. Mark is used by us as his a pragmatic, common sense approach to litigation. So, as well as obviously being a good lawyer, he's also aware of the wider commercial picture, and he's also very approachable. And as you'll no doubt find out, he's got a very informal manner that basically puts everyone at ease during conferences, etc. As he says, whilst his chambers are based in Liverpool, his practice takes him all over the country for court hearings, conferences, client meetings, and lectures. And the topic, as we'll have seen today, is the more specific topics of vicarious liability, non-delegable duties, and fundamental dishonesty. So I will leave you, Mark, to take it from there. Thanks.
Thank you very much, and good afternoon, everybody. Thank you for the introduction, Ian. Your check is in the post for that. It beats, as I said to Ian and others a few moments ago, the introduction I got from my daughter, my 16-year-old daughter today, who described me as the most annoying person who ever lived and who's ruining her special day and quite possibly her life. Anyway, there we are. She will at some stage be leaving home. I apologise for the absence of a jacket. It is very, very warm today, so I've removed that. So hopefully you'll forgive the lack of formality. I've been asked to look at a number of topics: vicarious liability, also non-delegable duties, and fundamental dishonesty. There are issues within those issues which I could talk about for a great length of time. So I'm hoping that we can get through this within the hour. I'll certainly deal with the salient issues, I hope. But again, equally, I hope you'll appreciate that these topics are topics that can be discussed at great length in their own right. So let's make a start and let's see where we get. Vicarious liability. Of course, the aim of vicarious liability is to assist claimants against potential defendants who, in their own right, may be individuals of straw, as it were. It's finding somebody with money to pay for compensation, and that's the whole concept behind the issue of vicarious liability, the topic of it. Insofar as we are all concerned, in its broad context, that is the NHS. And clearly our aim, whether it's through vicarious liability arguments, general liability arguments, or fundamental dishonesty, is to ensure that the paymaster is not the NHS. And so that is, as I say, our ultimate aim. It is paying, as I say, for somebody else's cock-up. And that's the reasoning behind the whole concept of this, strictly attaching liability to an employer for the acts or omissions of an employee or third party. I start with this particular case in terms of the legal principles. It's a Supreme Court case going back to 2013. It's an odd scenario that a lot of the vicarious liability cases which have emerged from the courts over recent years are in fact through, sadly, abuse claims by individuals who've been physically or sexually abused by certain organisations or bodies. And for obvious reasons, it brings in issues about whether the individuals working for those organisations or associated with them give rise to an attachment of liability to the association itself. This particular case set out the legal principle. There is a two-stage test. Part one is the nature of the relationship between the potential defendant and on the one hand and the tortfeasor on the other. Is the relationship one that is capable of giving rise to vicarious liability? So that's your stage one part. Stage two is, was the act or omission sufficiently connected to the relationship such as to justify vicarious liability attaching? So just distinguish between the two. Relationship from an employee-employer perspective, and secondly, in relation to the act or omission. It all gets a bit Keir Starmer-esque here because within that now we have subdivisions. So the stage one test in relation to the relationship, there are 5 factors. Is the defendant more likely to have means to compensate? The tort is committed as a result of an activity by an employee on behalf of the defendant. Is it a likely part of the business activity? Did the defendant create the risk of the tort being committed? Is the employee under the control of the defendant? There's an awful lot of crossover here with employment law and whether somebody is an employee for the purposes of employment law. And so it brings in many other associated employment cases. But those are the stage one factors. In terms of the Catholic Association case, going back to the 2013 case, the findings in relation to stage one by the Supreme Court was that the Christian Brothers and the Institute had a relationship which was actually closer in many ways than an employer-employee relationship, and therefore effectively that was the prime reason why the Supreme Court held that vicarious liability stage one test had been satisfied. And the Institute, of course, put the Christian Brothers in the position, it says poison there, forgive me, it should say position of providing the children with a Christian education. And so from a stage one perspective, the 5 bullet points that we looked at a few moments ago were clearly satisfied. Stage two, close connection in terms of the what was being undertaken, the abuse, sadly, which was meted out. One of the interesting features of this particular case was that in terms of the actual conduct of the tortfeasors themselves, it was felt that it was emphasised through their vow of chastity that essentially what they were undertaking, the torts they were committing, really emphasised the stage two aspect of what was actually being undertaken. So stage two was established there. So for obvious reasons, the vicarious liability attached. It's a very important case, this, in my view. It is a case which really sets out those bullet points. It can be a starting point for each of your approaches, and I'll come back in due course to tell you how I think it sort of translates into an NHS situation. But it's worth reading, at least insofar as the discussion section of the judgment is concerned. It's a very lengthy authority, but it's certainly one worth reading and taking the time to have a look at. Next case is a slightly more recent one of Barclays Bank and various claimants. This is in contrast to the previous decision. It is a subcontracted GP carrying out compulsory medicals with members of staff at the bank. The claimant's allegations were that this was a position akin to an employer. Defendant was saying that this essentially was a contractor. And that's the sort of basic background to this particular factual matrix, to this particular case. Stage 1 was rejected. And I have quoted from this particular authority here in terms of the boundaries of vicarious liability. And it's quite a useful quote because it was felt that the GP undertaking these medicals was an entirely independent contractor. So although, of course, they were putting the contractor in the position of dealing with other members of staff, they were putting them in a position whereby torts could be committed. It was found that the independent contractor effectively trumped that. And so this was a case where vicarious liability simply did not attach to Barclays Bank. The central conclusions, as I say, contractor, the GP was on business in his own account, medical practitioner, a number of patients and clients, and only one of those clients was the bank. Now, those two decisions from a common sense perspective, to me, seem to be very logical. One can see a great deal of common sense in terms of attaching various liability in the Catholic Association case through the actions of the Christian Brothers, as it were, in relation to Barclays Bank and that particular scenario. Again, common sense in many ways suggests, well, hang on, this is somebody that they merely brought in to deal with an isolated situation, an isolated set of circumstances. Should they really be held to be responsible? And they both seem to be fairly sensible in my view. The next case I just want to have a look at, however, seems to me to be a reining back of what during the late teens, 2000 teens, was an opening up of the vicarious liability. And this is a case of Morrison and various claimants. The factual matrix of these cases is often quite complicated, and I've tried to sort of bullet point them for you. But essentially, it was the unauthorized disclosure of personal details of employees by an IT auditor at Morrison's. It was an auditor who was actually sentenced to prison for 8 years from a criminal, clearly criminal perspective. Now, this was determined to be a stage 2 case. So what you need to bear in mind when you look at this authority and when you take it on board is that in terms of that 2-stage test that the Catholic Association case set out, the relationship between the tortfeasor and the employer, in this case Morrison's, there was sufficient nexus. So it then required the court to look at the actual acts committed by the tortfeasor to see whether stage 2 engaged. So in essence, there was effectively an employee, scenario established at stage 1, or at least a relationship sufficient for that to have that prima facie case. Was the activity part of the function of the employee? By that, was the disclosure of the information part of the function of the employee? Well, in one sense, no tort ever is, but it seems to me that somebody with access to IT systems and so on and so forth potentially was laying open the employer to establishing that stage 2. In the Morrison case, no, he was not authorized to disclose the information simply because there was a causal connection between the employment and the act. Didn't mean that stage 2 was satisfied. I see this case as a bit of a reining in of the vicarious liability expansion, as I say, which was taking place prior to 2020. There are a couple of other authorities you might want to have a look at. Sadly, a lot of these are because of the nature of the arguments about relationships between the employer or the organisation. A lot of these are abuse cases, and these are two more. The Watchtower and Bible Tract Society of Pennsylvania and the Blackpool Football Club case both involved, I'm afraid, a degree of abuse, and it was whether that gave rise to a finding of vicarious liability against the organisation. So they are another couple of cases that it's worth watching out for and having a read through. Contractors. I said I'd return to the issue whether this engaged. We shouldn't forget in terms of contractors, and the NHS uses a lot of independent contractors. There is a specific independent contractor defence at subsection 4B, but there is a significant caveat to this, which is the final sentence of that the contractor ought reasonably satisfy themselves that the contractor was competent and that the work had been properly done. So not sufficient to say for the purposes of subsection 4B, it's the contractor's fault, it's the independent contractor's fault. They are entirely independent of the NHS. You need to go through the procedure of vetting. You need to go through the procedure of do they have appropriate insurance? Do they have appropriate references, and so on and so forth. So it avoids the willy-nilly appointment of fly-by-night contractors, basically, all reasonable steps in essence. Non-delegable duty. We cannot forget that if we directly employ an individual, wherever that place of employment for them may well be, our duties to them are non-delegable, both in terms of common law and any statutory obligations which may apply to us as an employer. It's not something we can send out or farm out to somebody else. As I say on this particular slide, we cannot contract or subcontract out of that situation. How do we protect ourselves against that? I could wax lyrical at great length about scenarios that I have seen both within the NHS and outside, but it's about, in many ways, making sure that our contract is watertight. It's about making sure that we have appropriate indemnities, and of course, absent any indemnity clause within those contracts, it may well be that even though the contractor themselves, the subcontractor, forgive me, has been responsible for a lack of training with an individual, it may well be that unfortunately this comes to return to haunt the NHS insofar as those non-delegable duties are concerned. Kennedy and Cordia, probably all familiar with this particular case, Supreme Court case going back to 2016. It involved a number of issues, actually, one of which was related to the appointment of experts in cases. It's a useful case in that regard from a Part 35 perspective. But simply the factual matrix of this case, I think, is very a stern warning in terms of those duties. The claimant was an individual injured at a property, a patient's property, slipping on ice, going into that property. The reality is, of course, in so many different ways, the defendant in that case, Cordia, had no control, direct control over the property itself. Carers will be sent out by or on behalf of the NHS to a number of places where, you know, we see different types of property, high-rise flats, whatever it may well be, the whole gamut of occupiers in that regard. Still found to be liable. Insufficient steps taken in terms of risk assessing the attendance of that employee at those premises, failing to take appropriate action to protect them in terms of weather conditions and so on and so forth. And for me, it's one of those cases that really does highlight that although in many ways people would look at that. Members of the public may look at that, and so it's quite unfortunate and frustrating that the employer is held responsible for an area where they don't have that direct control. But it just shows that you cannot delegate out either to an occupier or anybody else the non-delegable duty that you owe to that employee. That deals in a very rattling way, and I'm sorry to use that expression because I don't mean to underplay the nature of the law and its importance there in that regard. But I do recommend you look at some of the cases that I've set out on the slides there. The lengthier topic here is one of fundamental dishonesty. And for that reason, I want to try and concentrate on this because for me, it seems to be an area which is very much flavour of the month, but it's also something which historically and for so many correct reasons has concerned the NHS in terms of how we run cases, issues that we raise, procedural points and so on and so forth. So I want to try and concentrate on this, if I may. I don't know whether any of you have ever read Shari Lapina. She's a Canadian author. My wife gave me a book on holiday last year. It's a sort of book you can read in about 4 hours, one of which is called Everyone Here is Lying. And it's an intriguing account. And it's a comment that was echoed to me by a friend of mine who acts for claimants and against whom I appear in a number of cases throughout the course of the year. And he said to me, we all lie. Everybody lies. It is the degree of that lie. It is the nature of that lie and the extent to which it impacts upon others, which is something that is for general consideration and perhaps a wider and more moral consideration. And in many ways, he's right. We can think of so many different examples. Yes, indeed, kids, Father Christmas does exist. Well, there we are. That is the start of it. As my wife pointed out to me, there are occasions when I say, you look lovely in that, darling. I'm not entirely convinced she either believes me or indeed that I believe myself. However, these things, these issues and these white lies, as it were, are features. We have to distinguish that for the purposes of our talk today from what is clearly described as fundamental dishonesty. And there is, in terms of the talk on this particular slide, there are 3 particular areas that I want to just have a look at. Firstly, the legal sort of principles that engage, the legal test in relation to fundamental dishonesty, some issues of procedure which arise, and also I've put them as tricks of the trade. Some people use the word tactics. It's how we approach certain issues. We all have, and within the law, there are always areas, there are always aspects of a particular case in respect of which we have a more tactical approach to it. It's not in any way, shape or form chicanery. It is simply how we deal with individual cases, horses for courses, as they sometimes say. So I'll deal with the legal framework. You'll all be familiar with this particular case, Ivy Genting Casinos. It is a Supreme Court case. Again, rather like many Supreme Court cases, it's quite a lengthy decision. There are a number of issues involved in that, one of which was what constitutes fundamental dishonesty. And there are 2 aspects to that. There is a subjective aspect and there is an objective aspect. Subjective, and in many ways this is a restatement of common sense. It emerges through a first instance decision going to Cambridge from a circuit judge over there many years ago who described it as pure common sense. What was the claimant's actual state of knowledge? You cannot have a claimant held fundamentally dishonest who held an honest belief in evidence that they have put forward, either in a witness statement, disclosure, or whatever. That clearly does fly in the face of common sense. So we need to know what the actual state of knowledge of the claimant was. The second aspect, and by reference to that, then in many ways, is was that conduct, was what the claimant did, said, or put in evidence dishonest by the standards of ordinary, decent people? So there's an objective element to that. It's the man on the Clapham omnibus, as they say. How do you approach that from a more objective perspective? And then finally, was that dishonesty fundamental to the case presented? And you have to have that in mind, those three aspects in mind, when you look at what represents dishonesty and fundamental dishonesty within a particular case. It's a term of art, fundamental dishonesty, which emerges from the Criminal Courts and Justice Act 2015. You know, those of us who are old enough and long in the tooth enough to predate that by, sadly, far too many years, see it as fraud or dishonesty. It doesn't matter how you dress it up. It is an issue of dishonesty or fraud. Burden is on the defendant. So although claimant always retains the burden of establishing the claim on the balance of probabilities, the burden of establishing that the claimant has been fundamentally dishonest in the presentation of that case rests on us. And so we need to get our evidence in place. We need to make sure that our evidence is in place if we are going to pursue that. And of course, the starting point for that in many ways is, are we satisfied in our own minds that there is not merely a whiff or a suspicion of something in the background? Do we have some positive evidence or evidence positively to challenge the claimant's account of either what happened or the claim for quantum or from a causation perspective? So bear that in mind. It is our responsibility, and it's a point I'm going to refer to or return to in due course. I mentioned the Criminal Courts and Justice Act 2015, Section 57. This is the Holy Grail, particularly with the sorts of work that we do here. I say that the NHS, because whether these are accident claims, whether these are, you know, trippers or slippers within the hospital premises, or whether they are claims arising out of potential medical negligence, 99% of the claim that we face will involve pain, suffering, and loss of amenity, and it's unlikely that there will be a pure and entirely unrelated property damage claim. The reason I say that, and without wishing to digress too greatly, a lot of the work that I do involves, for example, credit hire, motor vehicle accidents giving rise to very extensive claims for credit hire. There will often be cases simply not involving pain and suffering. It is now generally accepted that Section 57 would not apply to those cases. And so from our perspective, it remains, however, very, very relevant. The result, of course, is it can see the dismissal of the PSLA claim and everything that relates to that. In effect, the claim fails. More than that, you are then entitled per 4416 of the CPR to some recoverable costs on an indemnity basis. So it is a real holy grail for us in situations where post-2015, in most scenarios, we're not entitled to recover our costs even if we are successful. I put the final comment there, claim or claimant. Mr. Justice Knowles in Sinfield, and it's a case I'm going to come back to in a moment, said it would be rare for a claimant to be fundamentally dishonest without for the claim to be fundamentally dishonest without the claimant also being fundamentally dishonest, although that might be a theoretical possibility at least. It's difficult to think of one, and in typical High Court fashion, although Mr. Justice Knowles was covering his back, he didn't give any examples of that, merely went on to say that it was conceptually possible but may not occur in a general sense. For my part, if a claim is fundamental, if the claim is fundamentally dishonest, I struggle to see how a claimant who is advancing that claim, even through representatives, can escape that. What constitutes dishonesty? Well, this is a quote from Lord Hughes in Genting. Like the elephant, it is characterised by more by recognition when encountered than by definition. A wonderful judicial cop-out comment. Basically, you know fraud when you see it. Well, yes, we do most of the time. Most of it's very obvious, and I'm going to go through some examples in a moment. But it might necessarily be helpful for you to try and categorise those. But anyway, that is the comment. I mean, it's interesting in my experience of this that what is dishonest to one judge simply is often not dishonest to another. What is fundamental to a case, to a judge in one particular case, may not be to another. To the extreme of even within the same case. And I had this a few years ago where a judge at first instance accepted that there was something, I think the word used, it's again judicial speak for this, there was something curious about the claimant's evidence. Curious, you mean she's dishonest. I appealed that decision. First instance, the judge had asked me during the course of submissions the rhetorical question, how could you possibly describe the conduct of the claimant on this particular point as dishonest? The intriguing feature of that case was that when we got to appeal about 6 months later, the appeal judge turned that question on its head entirely and said to my opponent, how can you possibly argue that what the claimant did and said in this case was not fundamentally dishonest? So we had the same facts, the same, nothing introduced from the sidelines. This was the same facts. A circuit judge and a district judge who in law have no greater precedence over the other. I know a circuit judge in terms of a county court appeal trumps a district judge, but they don't provide an authoritative view, but a same sort of not entirely different level of judge from an authoritative perspective, taking entirely different approaches to the same facts. I see it as highly subjective. Genting, the Supreme Court authority, suggests it shouldn't be. I'll give you other examples. I can refer to him by name because he's now retired. His Honour Judge Trigger, a circuit judge from Liverpool, who was notoriously robust in terms of his approach to claims. A wonderful judge in terms of so many different reasons, an extremely colourful and interesting and engaging human being on the bench, who was very suspicious of claims. There was a judge in Manchester who was not. He shall remain nameless, but friends of mine said he never knowingly found for a defendant in cases very much on the same sorts of facts. So it is very much the elephant, as Lord Hughes has suggested, and it's something that we have to struggle with ourselves. And there will be individuals among you today who will have cases that you'll be looking at, and you will, as we all do, be passing that over to a colleague or a friend and say, what do you think to this? And you'll be getting different opinions about that. And that is the nature of fundamental dishonesty in my experience. Just as an aside, the very claimant sympathetic judge who used to work in Manchester, when he had his leaving party, I asked his usher whether it was well attended. She said, yes, it was, because everybody turned up to make sure that he genuinely was leaving. Anyway, he shall remain nameless. So the categories of negligence, the categories of dishonesty, rather like the categories of negligence in the old Donoghue and Stevenson case, are not closed. We have a list of things that I've put here. We've got entirely made up claims from a liability and quantum perspective. People who fabricate accidents at work. I've seen that with the NHS. They fabricate the mechanics of that accident to suit their case. They fabricate injury when in reality they may have had nothing more than some transient pain and stiffness for a couple of days. These things morph. We have fictitious heads of loss. One of the cases I'm going to come across and put you your way in a moment deals with simply that fictitious head of loss, which resulted in the whole claim game. Exaggerated claims. This is the most difficult area, and there's an authority again I'm going to take you through in a moment, which I wouldn't say makes life difficult for us, but it means we need to have a more nuanced approach, certainly, to exaggerated claims, layered claims, individuals who are claiming for injuries. Now, it doesn't necessarily apply per se in the NHS context, but certainly in terms of car accident claims, for example, it is now becoming de rigueur. I don't know whether you're all familiar with the fact that there are whiplash tariff injuries, which are very low, but certain non-tariff injuries which still attract the old form of assessment. So for the first time since time immemorial, we're getting people with knee injuries in car accidents, in fairly low-grade accidents. We're getting individuals claiming to have suffered tinnitus, claiming to have suffered some form of acoustic shock. And as a circuit judge in Leeds said in one of his cases, in the 30 years that he spent both in practice and on the bench, he saw no tinnitus claims. And yet, with the introduction of these whiplash tariff injury awards, they were becoming more and more prevalent. So these are the sort of layered claims, exaggerated claims. The final one, and this is an extremely important one, this is in my view, is one of the most significant areas from the perspective of the NHS, the Melodian Cambridge vibration case, the denied or significantly underplayed history, either of accidents or medical history. So those are the sort of principal areas. Let me give you odd other examples. I had a case recently, which was a case worth upwards of £300,000 in central London County Court, and we were listed for 10:30. By 10:30, the claimant hadn't arrived. My opponent came to see me and said, he's in the queue. The queue is horrific outside. I don't know whether any of you have ever been to the RCJ, but it's not the easiest of buildings to get into. I said, fine, let's go see the judge. So we saw the judge and said he's queuing up outside. We need to perhaps put it back a little. We've got plenty of time. It's fine. He arrived about 11:30. Turned out he hadn't been in the queue at all. He was parking about 3 miles down the road. And this became apparent within the first couple of questions of him on cross-examination. Wonderful response from him to me and to the judge. He said, well, I'm sorry about that. It was just a little white lie, the sort of white lie that you would say to a friend if you were late. And the judge looked at him and said, do you see any friends in this courtroom? And the claimant looked around and just said, it would appear not. And quite rightly so. I mean, it actually resulted in a finding of fundamental dishonesty by the judge in due course. There were so many other different reasons in this particular case why he was fundamentally dishonest. But the judge started with that and said he even lied to the court about why he was late and why he wasn't here to give evidence at 10:30 this morning. And that is a fundamentally dishonest approach, and it's abusive and contemptuous of the court's process. Astounding. There we are. It's frankly amazing the lengths to which some people will go. There are also no accident injuries alleged, as I say, subcategories again. The made-up claim entirely. The improbable accident mechanics. I had the joy once of cross-examining a chap in Liverpool who tripped on the pavement, and the description of it was so woefully extreme. And one of the things that he was claiming was that this £800 gold bracelet that he'd been wearing, a delightful piece of jewellery, a bit sort of Bobby George-esque, if those of you are of a certain age and remember the darts player, was lost in the process. When asked in court how that was lost, he said, under the pavement. Under the pavement, and he was very emphatic about how this had happened. It was just, it was the totally improbable account of the loss, which resulted in, I think again it was His Honour Judge Trigger, just dismissing that claim. We've got the bogus witness. I had the joy of defending quite a high-value car accident claim, both on liability and quantum in Liverpool many years ago. And perhaps this comes back to the point I made about subjective approach by judges, where the claimant introduced a bogus witness. And this individual turned up to trial. He was so utterly horrific that it was quite obvious within a few questions that he simply could not have been at the scene at the time. The irony of it was that the judge went on to dismiss the claim on liability, but found it was essentially honest and that the witness was not fundamentally dishonest. I then subsequently, it was a Friday night, I went out for a pint after the trial to meet another friend of mine who was a judge. And as I arrived at the bar, the judge that I'd been in front of, who dismissed my application for fundamental dishonesty, was standing at the bar also. He handed me a pint with the words, well, she was a lying cow, wasn't she? Anyway, it just highlights to you that perhaps he just didn't want to go that extra mile in court. So these are aspects of the claim that you need to have regard to. And in terms of investigating it, these are areas that require detailed investigation. There's always that search, as I say at the bottom, for somebody to blame. Sinfield, I said we come back to this case. I don't know how many of you are familiar with it, but it's a lovely case in terms of, in my view, how the NHS should run some of their exaggerated claims. An entirely genuine accident, an entirely genuine injury, and not an insignificant injury suffered by Mr. Sinfield. The problem was that he introduced a very dodgy claim for gardening services. And not only did he introduce a dodgy claim for gardening services, he went on to fabricate some dodgy invoices so that he could recover those. And he was uncovered. And as I say, it wasn't a significant aspect of the claim. The claim for PSLA in its own right was, in so many different ways, a justifiable one. But it was the presentation of this dishonest aspect which resulted in the whole thing disappearing. In my view, an extremely useful case, because more often than not, particularly in our clinical negligence claims, there will be at the very heart of it a significant honest aspect to it. But that doesn't mean that we have to accept everything that comes with that and not challenge positively every other aspect which is pursued by the claimant as well. So to bear that in mind, it's a very useful case. Elgamal. Now, again, I said to you the exaggerated claims are something that you have to have a more nuanced approach. And look at this. This is a direct quote from this High Court authority from Mr. Justice Jacobs. And I start with this. Before we look at the quote, I'm not going to read it all out to you. It's there in front of you to take note of. Bear this in mind, that even in the most honest of claims, even where there is an honest accident, a genuine breach of duty, a genuine injury, and genuine claims, possibly even for care, assistance, and so on and so forth, so we don't have the Sinfield approach, claimants in their statements will never tell you how well they were. Claimants, in my experience, and this is why in so many of these cases you simply don't want to put a claimant in the witness box, claimants will never say, it was fine, I recovered very quickly. Why don't they do that? Well, of course, they engage the services of a solicitor who wants to set out how this injury or series of injuries impacted upon a claimant's life. That is not in my view, and Elgamal reinforces this, fundamentally dishonest. It is the natural exaggeration that we see, or natural emphasis, perhaps is a better word, that we see from claimants when they are dealing with their statement and the statements of others who support them in these cases. And as I say, it's a comment from a circuit judge friend of mine many years ago who said, really, you know, unless you do have some strong positive evidence, claimants, as I say, will never tell you how well they were from the witness box. Melodeon Cambridge, I said this was extremely important. It is. This was a whiplash injury claim, but, and of course, in a whiplash injury claim, there is generally no objective evidence. And this is why this particular comment was made by Mr. Justice Spencer, a man who is very robust for defendants in these cases. He's a very, very good High Court judge from our perspective. A lot of what a claimant advances can only come from the claimant. Yes, if he's broken his arm, there's an X-ray, but the effect of that broken arm upon him and the history of symptoms that he may or may not have had in relation to that arm previously. Perhaps a broken arm is a poor example. A dislocated shoulder, which is something which regularly occurs and can reoccur. A claimant who lies to his medical expert or misleads the medical expert about that history falls foul of Melody. It's an extremely important case to look at. It means that we do have to trawl through medical records. We do have to look at accident history. We do have to look at claims history. And we have to be certain that what the claimant said to that medical expert was genuinely put forward. Extremely important case. It is one of the most used cases in my experience in dealing with fundamental dishonesty within the personal injury claims area. Is the question of causation relevant? Does it matter if, for example, you put questions to the medical expert and that medical expert then says, oh, now you tell me about that history of the shoulder dislocating, I'm going to change my view slightly. Here's my view. It goes from a 2-year claim to a 6-month claim in terms of attributable pain and suffering. Well, no, I don't think that gets the claimant off the hook, because the problem a claimant always faces with this Melody case is that they gave you a medical report at the outset which was simply untrue, and they didn't clarify it. Let me tell you how they should clarify it. Many, many years ago, I had a car accident which involved a nasty shoulder injury. And I was asked by the medical expert, an orthopedic surgeon, whether I'd had previous accidents. My comment was, I'd been unfortunate to have been involved in quite a few car accidents, some of which had caused injury, some of which hadn't. But there we are. You know, my medical records were available for review. Quite a few of them were during my childhood. He failed to put that within the report, and I insisted when that was disclosed as part of a claim that there was a caveat from me saying, this is what I told the medical expert. I do not want anybody believing that my history was kept from him. You know, that is the way to get around these problems, and that is the way for a claimant to do so. Disclosure dishonesty, this is another aspect. And Hayder and DSM demolition makes it clear that if you don't produce documents, because disclosures are not based, disclosure requires you to provide documents that are not helpful to your case. Most people don't want to do that. And if they are already dishonest in terms of the claim, they're not going to do that. And Hayder and DSM demolition makes it clear that that in its own right can be fundamentally dishonest. Brings me on to my final point on this particular aspect of the topic, which is demeanour. Demeanour, and these are two quotes or two cases here. Mr. Justice Leggett it's the SS Sri Lanka case. Forgive me, it should be cited there. Demeanour shouldn't be relevant apparently, because judges tell us that they're not psychologists, and therefore it's impossible for them to say whether by staring at the whites of somebody's eyes they're telling the truth or not. Mainline Digital and Richards tell us that the most important thing is to look at the documents. So if there is an inconsistency in the documents which is completely inexplicable from an objective perspective, then I'm afraid it doesn't matter how good a witness the claimant was in the witness box. I'm afraid that trumps all. So that's something that you need to bear in mind. However, it's sheer and utter nonsense. The reason I say that is because much as they will tell you, judges, openly and expressly, demeanour does not feature in my case. There's a recorder friend of mine who said, I'm not an amateur psychologist, therefore I don't have regard to how the claimant gave evidence from the witness box. My findings are based on the following documents. Of course they do. Of course they do. They look at the claimant. The late Charles James, former circuit judge of Liverpool, used to stare at people almost as if to bore through their soul to try and find out whether they were telling him the truth about a particular accident. Again, Ian Trigger, who I've mentioned previously, would be really robust in terms of his own questioning of witnesses to see whether they broke down or whether they were standing up to him in terms of how things happened. Of course, psychology plays a part. What they do, however, is just not mention that and demeanour within their judgment. So, again, if you, from your perspective, when you're dealing with these cases, think, I'm not sure the claimant will be a good witness, there's a history of criminalities from the medical records, for example, then you can bet your bottom dollar that that's something that will be borne in mind by a judge in due course. Let me look at some of the procedural issues which will help you. Pleadings. We all know, certainly should do from Howlett and Davis, that you don't need to plead fundamental dishonesty. But what you should also know from Pincus, Gajano and Jenkinson in particular is that you need to set it out in some way, shape or form. You cannot turn up to trial and say to a claimant, you're fundamentally dishonest because you lied about your history. If you haven't flagged that, potentially, even in correspondence, as an issue, it's extremely important. And it doesn't have to be pinning our colours firmly to the mast. It can be highlighting an issue. You can put it as neutrally as saying, we have concerns that the account provided is inconsistent with the medical record entry, and we cross-examining the claimant about it. If that claimant is found wanting in terms of cross-examination, then we'll be inviting the judge to make a finding of fundamental dishonesty. Words to that effect are sufficient. You don't need to formally put and pin that through Howlett and Davis. Disclosure. You have an ongoing duty of disclosure, so if you find something out about a claimant, technically we are therefore supposed to produce that, and if necessary produce an amended disclosure list. You'll all be aware, per Locke and Stewart, the first instance decision, actually it's now Lord Justice Edis who was the trial judge in that case, so a fairly decent judge, that you need to set out a statement of, if you're dealing with social media, of what all of the entries mean, the dates and so on and so forth. But don't forget, this is the Supreme Court. In many ways, it doesn't matter what the CPR specifically tells us, because by reference to the CPR, and it isn't exclusive in that sense, it's not a common law decision or authority, Thacker and Gracefield, fraud unravels all. If you find something out about a claimant, you can use that evidence. And bear that in mind in terms of how you use that in terms of a case. Tactics and tricks of the trade. Don't make unnecessary admissions. If you have a case, let's say, for example, this is the best example, if you've got a case of a tripper or a slipper, a tripper in particular, for example, a member of the public walking in through the main entranceway and there's a wobbly paving stone, you may need to admit that you've breached your duty. You didn't inspect it, maybe. You may also accept that it measured more than an inch and it was a danger, but you don't need to accept that you're liable. You don't need to accept that the claimant fell as alleged, because you can still put the claimant to proof about that. And again, you're not challenging them per se from an honesty perspective, but what you're saying is you've still got to prove your claimant. There's no CCTV here, for example, and we'd like you to establish that this accident took place because of that, and not because, for example, you tripped over something else. So again, bear that in mind. It's extremely important. Investigate the heck out of it. Look at the medical records. how many people let themselves down by telling the GP that an accident took place in one way, and yet they then claim that it took place in another way? Astounding. How many people post on social media? I mean, look at that wonderful case with the couple from the Wirral a few years ago who were claiming for holiday sickness against a particular travel company, and were literally posting photos of themselves dancing on the tables during the period when allegedly they were in the hotel room, throwing up and unable to enjoy themselves. It's people forget social media is not private. It can be if you apply the appropriate settings, but if you're foolish enough to put it out there and it is wholly inconsistent with your claim, I'm afraid you don't have anybody to blame apart from yourself when it does return to haunt you. Ancillary records. The man who was a rugby player in a case that I was involved in, and who was there on the rugby club website receiving Player of the Year award, and all sorts of other plaudits at the annual dinner in circumstances where apparently he couldn't leave the house because of his dodgy back. Well, there we are. We were able to trawl through those records and see really that he was lying to the court. Don't put your cards on the table until you have to. Comes back to that point about fraud trumps all. Don't forget that in video surveillance claims, we are surreptitiously, and I know we don't do it in every case, but we are surreptitiously following a claimant and getting evidence. Strictly, that's not CPR compliant. But the High Court in Douglas and O'Neill, as you see from the quote, and also in Hall and make that Rawle and Hume, forgive me, make that particular point. So set the trap in a way, the sandpit. Make sure that you tee the claimant up. What you want the claimant to do is tell you, for example, I couldn't do X, Y, and Z, you knowing in the background that he did X, Y, and Z. And so it may well be, and you're not being sneaky or difficult about this, that you get him to pin those colours to the mast before you release that information, rather like the surveillance evidence. So again, we have the other, so long as it doesn't amount to trial by ambush, and that's Rawle and Hume, it doesn't affect the timetable, and fraud again is the overriding factor. So in terms of conclusions, we need to be sceptical, approach every case with scepticism. That is not having a lack of respect for a particular claimant. It is merely challenging, in my opinion, the nature of the case and making sure that in whatever shape or form, within the limits of the CPR, within the limits of the authorities, that we save some money, whether that be on liability or through quantum. Let me give you just three very quick examples. Well, they're all one example. 3 cases I had within the space of 2 years for the NHS worth about £750,000. In each case, liability and the liability trial lasted about 5 minutes. In one of them, the claimant from the witness box said through his counsel, you cannot raise fundamental dishonesty, it's not formally pleaded. The judge said, yes, it can be raised, and it's been raised properly. The claimant panicked, flapped, went outside and discontinued. £750,000. Same thing happened to me in Carlisle. Same thing happened to me in Preston. 3 significant cases. I worked out today, that's roughly 225 MRI scans, and it's 9 or so grade 2, 3 nurses. My own view is, although it is in some ways unsavoury and it's not something necessarily that we want to do in every single case, but by investigating these claimants, that is what we were able to save. So if it is viewed as disrespectful or whatever, my retort to that is there's nothing more disrespectful than taking the pride of the United Kingdom, which it is the NHS in so many different ways, and abusing that for the purposes of compensation. So you're not, in my view, overstepping the mark. Final couple of conclusions. Make sure that you reassess claims. Issues of dishonesty, evidence of dishonesty comes out at all stages. If you had it at the very outset, if you had all of the evidence at the very outset, you'd plead it and you'd put it and there wouldn't be a problem. It's not how the way litigation works. We get phone calls midway through litigation to say, did you know that this is a made-up claim? Right, let's investigate it. We find out that it is. And then, as in one case that I had, the former claimant is then sent for committal for 9 months for bringing that fraudulent claim against the NHS. So these are things that move over time. If the claimant chooses to do nothing about this evidence, then that is the claimant's fault. The claimant has the right to do so. I think that brings me to my thank you. I said I'd try and get it into an hour, and I think I've just done that. Barristers for life and not just for presentations. But thank you for giving me the opportunity to speak. I hope you did find that engaging. I hope that you don't share the view of my 16-year-old daughter that I am the most annoying person that's ever lived. And I hope to see some of you at trial or in conference in due course in just this sort of case. Thank you.
Thanks, Mark, for managing to make some quite dry topics very interesting. We've probably got just a couple of minutes if anyone does have any questions. I know we've had one during the talk, which I think comes back to one of the points you just made, Mark, about raising insufficient time. I'll just read that out for you. Whilst working on a claim, if the claim handler sees or believes the claim to be dishonest, but then the judgment is made in favour of the claimant, then can the defendant take it to appeal?
Yes, they can, is your straightforward answer to that. And the Melody case, have a look at Melody. I recommend it to you. In Melody, the first instance judge, His Honour Judge Peter Main Silk, then QC, obviously would now be KC, he's since retired, found that the claimants were essentially honest people. And despite all of the inconsistencies in the medical records and so on and so forth, not only did he not dismiss the claim because of those inconsistencies, he gave an award of damages to them. And Mr. Justice Spencer on appeal said he's been beguiled too much by the demeanour of these individuals. The inconsistencies are so grave that not only do they not get compensation, not only do they not establish their case on the balance of probabilities, they are fundamentally dishonest. And so, yes, you very much can do so. And I have done that on appeal myself.
Great. Thank you. We've had another question. Can you please clarify once again what main things a Howlett letter should say as a bare minimum?
Very difficult without the specifics of a particular case. Let's take again the Melody example whereby you've got a medical report saying no previous medical history or no previous accident history. But when you look at the medical records, the dislocated shoulder they've suffered 10 times, as I've seen, in rugby accidents over the years. We all know that dislocated shoulders, as I say, do recur. Now, you may want to say, I personally would plead that as fundamentally dishonest within the defence at the outset. If you want to take a slightly more cautious approach, and both approaches are entirely legitimate, you might want to put some questions to the medical expert to say, is this most definitely what the claimant said to you during the course of the examination? Because we've seen this in the medical records. And so your Howlett letter there would say, we're very concerned that the claimant has, on the face of it, misled the medical expert. We are going to put some questions to the medical expert. If he comes or she comes back and says, no, that is exactly what I asked of the claimant and exactly what was said, then we will be raising an issue of fundamental dishonesty. And it's something we'll be challenging the claimant about on cross-examination. That's a perfectly open way to deal with that for the purposes of a trial and protecting your position.
Great. Thank you. I think that is it for the questions. So just to thank everyone for attending and another reminder, if possible, to complete the feedback. And thanks again to you, Mark.
No, thank you all. Thank you, Ian.